Hi, I'm Chris Chimicles, president of Angeion Group, and welcome to our Leading Litigators series. Our series brings together some of the best and brightest class action practitioners from both the plaintiffs and defense bars, and most importantly, the attorneys that made case law. Enjoy our series.
Hi, I'm Steve Weisbrot. Thank you for joining us for another episode of Angeion's Leading Litigator video series. Today it's our distinct pleasure to have Steig Olson, a partner at Quinn Emanuel, joining us. Thank you for joining us, Steig.
Thank you for having me. It's great to be here.
One of the things that makes your practice so unique is who you represent. On the one hand, you have a prolific plaintiffs practice, but you also represent defendants and monopolization claims, lots of different types of companies, and you even have an opt-out practice. I was wondering if you could just kind of elucidate for our audience what it's like to wear all those different hats, because ideologically, it's a little different than most of the guests we have on the show who are on one side or the other.
Sure. It's a good question. It's one of my favorite things about the firm, that it allows me and others here to do that, and it's relatively unique. During most of my career, I did mainly plaintiffs' work, nearly exclusively, and enjoy it. I think the plaintiff side can be more exciting sometimes. It's more entrepreneurial. You get to tell a story in some cases, build a case, but the defense side work has its own interesting elements of it too. There's more direct client relationships. Often Sure. You are sometimes coming in to help a client really in need, and you see things from a different perspective. And so I really enjoy doing both, and I think that you pick up, the folks of us here at Quinn who do that pick up insights that we can use on either side because we've been on the other side.
Sure.
And I know sometimes people can view things only one way when they only do it one way, but it does have challenges as well.
Not to give us the recipe for the secret sauce, but are there any specific examples that you could use or that you could share with us about using an insight from one side or another to get a deal done, or even posturing a discovery, just something that we could have a more concrete example of that?
I'll have to think of a concrete example. I would say I think there's a tendency to think that the other side has everything figured out behind the scenes
Right.
when you're only on one side. And then when you're on the other side, you realize that's often not the case. So
Right.
On the plaintiff side, I think there can be a tendency when you're watching what the defendants are doing to imagine that it's all carefully crafted, worked out. They're executing some strategy like clockwork.
Right.
And then there's a lot of energy trying to figure out what exactly is the angle here. When you're on the defense side, you see the dynamics behind the scenes and you realize the complexity, the great deal of complexity. There is the complexity of working with a client who might have opinions that differ from yours, who might have specific directives to make an argument in a brief, even if that argument might not be the best legal argument.
Sure.
There's the dynamics of working with the other defense counsel. It can be very messy. And so just knowing that is going on sometimes on the plaintiff side, you can spot when that might be happening. You can look for openings to exploit. And so that's something that I think we're able to do. Whereas when you're on the defense side, I think often in the defense practice, the plaintiff side is really a black box,
Right.
particularly in the class action practice. It's the rare defense lawyer in the antitrust side who has any insight into what's happening behind the scenes with plaintiff's counsel, how they're selected, who these people are, how they get their clients, where
Right.
these clients come from, how it all comes together. And there are openings there to exploit too when you're on the defense
Sure.
side. And so it's part of it is just seeing where vulnerabilities might exist.
One of the areas that you also partake in is opt-out representation. I'm wondering if you could give me a little bit of the insight into what that's like, where that kind of falls on the ideological spectrum that we were kind of just discussing, plaintiffs versus defense. Is it an indictment of the class action device when there is an opt-out representation? Just your thoughts and general thoughts on that matter.
Sure, all good questions. So in our practice here, opt-outs normally come to us.
Right.
We have a lot of firm clients, we have a lot of large clients. It's a combination of they becoming aware of a large class action or a large class action settlement and coming to us and saying, what are our options here? What should we be doing? Should we stay in the class? Should we think about other options? On occasion, because of our insight into the class action bar, we become aware of big class actions happening that implicate our clients and
Sure.
can bring that information to them as well. I would say truly, at least for us, because this is not a huge portion of our business, every case is unique. There are cases from time to time where a client opting out might be to some degree because there are questions about how the class action is being litigated or because of how it was settled. There might be a belief that more could have been achieved, perhaps. And that does happen. There are other times where it could make sense for a client to opt out that do not in any way impugn or question anything about what the class action lawyers did.
Right.
Class action lawyers could do a great job in a case, and a client for particular reasons, for particular individualized reasons, might feel that they can pursue their claims better on an individual basis. So that's something we'll help a client assess.
Well, that makes sense. I'd be particularly interested to hear your opinion on sort of the most important trends that we're likely to see over the next year, specifically because you have this kind of balanced practice where there's plaintiff side and defense side, and I think that your insight on that point is particularly valuable. What do you think we're going to see, specifically class actions or even antitrust, just in the antitrust world, however you want to answer the question?
Sure. In antitrust class actions, I think one of the most interesting things going on is one might consider one of the final waves coming out of the financial crisis.
Sure.
We've seen large waves of actions involving mortgage-backed securities, for example, coming out of the financial crisis where there was fraud. Those were pursued not as antitrust claims, usually as fraud claims.
Right.
What I think we have seen is the other insight that was gained as a result of looking at what happened in the financial crisis was seeing bank collusion. And, for example, if you look at the LIBOR matter,
Sure.
Which and to some degree helped trigger this, and these cases can lead to each other as the investigation not only investigates what happened with the particular financial instrument, but necessarily implicates others as well. So there are a host of cases at a relatively early stage now in the class action bar involving complex financial products by the banks, alleging collusion by the banks with regard to the financial products. There are two general categories. One is various benchmarks that the banks set, such as LIBOR.
Right.
And the allegation is that they colluded to set that benchmark or establish the benchmark in a way that favored their own self-interest as opposed to doing it in the objective way it was supposed to be set.
Right.
There are other cases that we've been involved in and are involved in that have more to do with market structure, where the allegation is that the banks colluded to protect a market structure that served their interests better than more modern market structures that would serve the interests of investors. So I think those are the case. There are a number of these cases. There are a number of things about them that are somewhat untested and will be interesting to see how courts respond to.
Which are the tougher cases of those two structures?
Which are the tougher of the two? Well, I think they each have their own challenges. The benchmark cases, if I had to choose, maybe have more challenges in some ways. As we've seen in the LIBOR matter, the LIBOR matter is one where there are huge fines being paid out, there are admissions of wrongdoing, and yet the plaintiffs have had a difficult ability establishing a legal theory on a class-wide basis that has convinced the court. And that other benchmark cases might find that to some degree. One of the challenges there is how to present them as class actions.
Right.
They clearly did, from a general perspective, implicate a broad group of investors.
Certainly.
But the defendants have arguments that they impacted those investors in different ways. You see that argument in every class action, but I think defendants will focus more on those in the benchmark cases.
That makes sense. It's been our absolute pleasure to have you join us here. Thank you again.
Oh, thank you.